Nice. The name of our law firm is Ellick Jones. Some nice people, small office. But today, talk about estate planning or end of life issues. Sense of the theme is being organized and trying to communicate after you can't communicate anymore. That's really what all this stuff is about. But start thinking about end of life issues. But what would someone need to know if you're not here to um, wind up your business, your the things that are going on in your life. Um, and so things that so I used to tell people to put passwords on there, but you got to change your password so often. That's not helpful. Eventually, people will figure out how to get your passwords. But the things that are helpful are list of all of your bank accounts, um, the bank account numbers, kind of a rough estimate of what the value is, so that they know which ones are important, where they're located at. Um, if you have a stock account, um, a list of that. If some people know the basis, the cost of stocks, that on there because that's kind of a pain to try to go back and recreate. But if you have that, it's helpful. Um, but and so it's kind of picking out which things are important to keep and which ones aren't necessary. So you're like your MED bill or OPP bill, I've decided aren't necessary for you to keep. If you ever needed that, they keep records. You could ask them for a history of it. But the assets are important. Real estate, if you own more than your house, a copy of the deed is helpful to have. The value, your guess is the value. If there's any liens against the house, that eventually they'd be found out, but to let somebody know that's handling your affairs right off the bat that there's a lien or a mortgage or a deed of trust against it. Um, those are the pretty obvious ones. Then you get to life insurance. I think a lot of life insurance gets lost. Um, it you know I talk about sometimes when someone passes away, you kind of live off the mail. You kind of see what comes in the mail and you deal with it one by one. And so you would think eventually you'd get a life insurance bill or some sort of statement in the mail, and that would put the person that's handling your affairs on notice. There's something there to look at, but sometimes it doesn't happen or it's just not there. So list of life insurance, and again, whatever you know about it, if it has a cash value or it doesn't have a cash value, how much it's supposed to pay upon your death, um, who the owner is, and then who the beneficiary is as far as what you think it is. And then, you know, I guess if you're making this list, then we'd want to know the location where the policy is actually at, where you keep it at. Some people keep all their important papers in a filing cabinet at their house or a fireproof box at their house. Or some people keep that type of material like in a safety deposit box at a bank. Um, I'm okay with all those, but I prefer the fireproof box or filing cabinet at the house over a safe deposit box at a bank. Um, just because I've seen a lot of sometimes it's difficult to get into the bank box. You pass away and then your kids go to the bank and say I need to get into mom's bank box. And they say you can't because it's hers, not yours. And so then you end up having to go down to the court, get an order from the court just to get into the bank box. And sometimes that might take 2 weeks, 3 weeks, a month. And sometimes it's just easier to keep it at home. Another one to keep track of are retirement accounts. Sometimes you have a retirement account from two employers ago, IRAs, annuities. Again, the value or the contributions you've made into it, so that the person taking care of things, knows generally what's there. Um, and then Social Security, um, how much, if you're getting Social Security, how much you're getting, or Social Security disability. Again, my wife's yellow pad of paper, how much is coming in, how much is going out every month. Um, Keeping track of cars is easy enough, because you look in the driveway and say, okay, mom had two cars. But sometimes you might have some antique car that's kept someplace else, um, or special items. The If there's artwork that has great value, or um, okay, I'll tell you another story. My dad collected antique bicycles, and he had a lot of them. But he pulled me aside one time and he said, "These over here are junk. Feel free to throw those away. But these two over here, those look like junk, but those have value. So don't throw those away with the rest of them." So now I suppose you know some people think things have a lot of value, and after they pass away, the kids try to go sell it. Mom said this thing was worth a lot of money. They find out that it really isn't. But at least giving your kids the thought of what you think is valuable is helpful. Um, so making that type of inventory is helpful. If you have a business, um, a description to your kids as to what that looks like. For me, I'm a partner in our law firm, and so I could tell my kids what's supposed to happen after one of our partners dies. Um, some businesses have buy-sell agreements that says, if you leave, this is what's going to happen. If you die, this is what's going to happen, or not. Um, I think typically in Omaha, most people are trustworthy and they would tell the kids, but it's good to have that confirmation on the other side as well. Um, and then when we're talking about estate planning, um, we're generally talking about documents, a couple different documents. Um, the first one is a healthcare power of attorney. This is a document where you can appoint somebody. Um, you can appoint your spouse or your kids to make medical decisions for you, but only in the situation that you can't make those decisions yourself. And so you list your spouse or your kids on this document. We usually put their cell phone number on there. And then the next time you go to the doctor, you give him or her a copy of it. And they scan it into their electronic records, so the hospital has it. Um, and then if they need to get a hold of you, they need to get a hold of your decision maker, they'd have it there, and they could call that cell phone number and have them come in and talk about what's going on. And obviously, an emergency situation, they can do emergency procedures without consent, but um, for non-emergency situations, they like having someone give consent to do the procedures. In that document, um, you can tell your decision maker what your thoughts are. Again, communicating when you can't communicate anymore. What your thoughts are on the situation, that if you're in a vegetative state with no hope of recovery, what do you want to have happen? And people have legitimate differences of thought on this. Um, some people want to be kept alive as long as possible, because you just never know. Uh, Maybe your body will change, or maybe some science will come along that will change your situation. Other people, if it's truly no hope of recovery, they do not want any additional extraordinary measures taken. And So we say that if that's what the people want in their healthcare power of attorney. So you tell your decision maker, if I'm in that situation, I want you to tell the doctor that I don't want any extraordinary measures taken, any more extraordinary measures taken. I've had a few clients who are neurologists, and we get to that point, and they always give me grief, and they say, "Well, um, what does that mean?" And because science isn't exact, uh, it's the art a lot of times, and a lot of times you just don't know if there's really no hope of recovery, and uh, so the state of Nebraska has some definitions of them off because sometimes it's good to talk about them. And this is how the state of Nebraska, because we use the term persistent vegetative state. If you're in a persistent vegetative state, so what's that mean? It means a medical condition that to a reasonable degree of medical certainty, as determined in accordance with currently accepted medical standards, is characterized by a total and irreversible loss of consciousness, so you're not conscious, and you've lost your capacity for cognitive interaction with the environment, and there's no reasonable hope of improvement. So you're not conscious, you have no cognitive interaction, and to a reasonable degree of medical certainty, the physicians are saying that there's not a reasonable hope that that's going to change. Sometimes we use the term terminal condition, and obviously we're all terminal, we're all going to die. But what's that mean for the state of Nebraska? And they define it as an incurable, irreversible condition that without administration of life-sustaining treatment will, in the opinion of the attending physician, result in death within a relatively short time. So a lot of the definitions have slush words in there, reasonable, relatively, um, and so the doctor is always going to talk to the family about these decisions, and, um, and the family can take some time to make the decision if whether to continue care or not. But it is an emotional decision, um, and so sometimes I have clients that say, I don't want to put my family members through that. Is there another way to do this? And there is. There's another document called a living will. And what a living will is the direction from you to the doctor specifically on that question alone. If I'm in a persistent vegetative state, do I want extraordinary measures to continue or not? Where the healthcare power of attorney, you tell your son to tell the doctor, the living will cuts the middleman out. It's just from you to the doctor. Now, some people don't want that living will at all because they want that middleman. They want the advocate to be stopped and think, and let's take a couple days or a week to see if things change and really sit down and think about this. And so some people definitely want it to be in the healthcare power of attorney, and other people want the living will so that there's a direction to the doctor directly. The next document is another power of attorney, but rather than for healthcare, it's for business purposes. So you can name someone to sign your name to help you in business decisions. They can change your cell phone contract. They could sign your tax return. They could sign a lease for you. Um, sign your sign your sign their name to your checks to pay your bills for you. Anything that would help you. It is unlike the healthcare power of attorney because the healthcare power of attorney only works if you can't do it. This business power of attorney is effective now. So even though my wife is just a mile away from me, um, and I could do stuff myself, she could take the power of attorney I've signed for me, giving her permission to do stuff, and go do stuff for me. So she could go to the Verizon store and change her cell phone contract for me. Um, um, I don't know. I need help with lots of things, but she could go set up a new account for me at the dry cleaning store or something. But it's called a durable power of attorney because it continues to be effective if I do become unable to handle my own affairs. So, like when my dad was out at the nursing home, um, he enjoyed paying his bills, but he couldn't do it anymore. So I would take his checkbook out to the nursing home and sit with him, and I would sign my name to his checkbook to pay his bills for. So we could get his business stuff done. Um, so obviously, you can do all these documents on your own. You can pull them up on the internet. But I'm a lawyer, so I think there's value to having a lawyer do it because once in a while, I do see ones that people have done on their own, and most of the time they're about right. But it's those little things that are missed that can cause a problem, and so I think there's value in seeing a lawyer. So if you visit with a lawyer about these issues, it's good to bring an inventory or talk about what your assets are so that he or she knows if there's any strange assets you need to talk about. And then discuss, what your thoughts are on the healthcare power of attorney or the living will, um, and burial plans. You know, None of these documents talk about what your thoughts are for what you want to have happen to your body after you're gone. And that's because you don't control your body after you're gone. Your family does. Um, So sometimes we'll put a letter of instruction in with the will, but it's not binding. It's just whatever the family wants to do. But sometimes I have people that have very specific religious things that they want to have happen. Other people want to be cremated, or other people do not want to be cremated. Um, if you have a prepaid funeral plan, it's good to write that in there. I've seen, you know, burial has to happen fairly quick, and seeing the kids bury mom and dad over here, and then about a month later they find out they had a plot purchased at this cemetery, a couple miles to the east. So again, writing it down so the kids know that. Also telling the lawyer, having a list of all the family members' names and spellings, because sometimes we get the spellings wrong or their phone numbers. Um, Also, which family members are kids, because we have to treat kids differently in this estate plan. Um, and if any person that we're giving money to in the will, I'll talk about the will in a second, has special needs, that's important for the lawyer to know. We don't want to give money to somebody and have the money harm them. And the money can harm them in a couple different ways. One, if they're on Social Security disability or Medicaid, um, giving them an inheritance could disqualify them from those government benefits. And so there's a way to handle that, but it does take some extra documentation to um, say that they can have this money, but only if it doesn't disqualify them from government benefits. Or sometimes I have, obviously, we all have family members who have addiction problems, and if we give them the money, they're going to use that money to harm themselves. And so we don't want to give them the money. There's ways to have the money benefit them without harming them. We can give the money to a trustee who keeps the money and just pays their bills for them, or make sure that it's used properly, not just giving them a free reign, or they're just not good with money. They'd spend it all on or something. So a lot of real life uh, issues that are good just to talk about out loud. Um, it's also good for the lawyer to have a list of any advisors that you work with. If there's a particular accountant or a financial advisor, just for the lawyer to have that name and phone number in the file in case after you're gone, there we need to coordinate stuff. That's helpful. And then if you have children, um, we need to know who you want to be the guardian. Obviously, if you're married, your spouse, or if you're not married, it's just the other parent is the natural guardian. But after both of you are gone, who would you want the guardian to be? Um, I'm getting short on time, so let me just run through the will um, for a minute. The last document that we normally talk about is a will. So when you pass away, the healthcare power of attorney and the business power of attorney go away, and the will takes over. First thing it says is who's in charge when you're gone. Most states call it executor. Nebraska calls it personal representative. Um, so there's no normal, but you see often husband names wife, wife names husband, and then on the second of you to die, you can name one of your kids, or it doesn't have to be. You can name a brother or sister, or it can be someone that's not related to you at all. Um, but it is, a little bit of work, so you want to think about who you want to do that and make sure that you think that they have the business capacity to handle it. And in the will, you tell that executor what to do. That is, first thing is gather all of your material and all your assets, and pay all of your last bills, and then wind up all of your outstanding uh, circumstances. And then if there's any money left over, do this with it. Um, you can do that with specific dollar amounts, um, but typically we don't necessarily know how much money you're going to end up with when you're gone, so we end up doing percentages. Um, you can do, certain dollar amounts if you're naming a few people or charities, and so you're going to give them each, $5,000, $5,000, $5,000, and after all those, then the majority or the residue of the estate goes a third, a third, a third to the kids, something like this. And then the question I usually get around January 15th is my clients come in and say, Dan, I was at a Christmas party, everybody's staying around, we had a trust. Why don't I have a trust? I say, I'll be happy to write a trust for you, but I usually like a reason to make a trust. There's different reasons we use a trust. One is, again, if we want to have the money be managed by a professional or somebody other than the person that's going to benefit from the money. We give the money to a trustee, they handle it, just pay allowance to the person getting it. And that could be because elderly and they need help. Um, they have an addiction problem, and so we want to manage it for them, or they have a disability and we want to manage it for them. Or sometimes we have a situation where we have a husband and wife get divorced, get married again, but they each have kids from their previous marriage. So she has her kids, he has his kids. They're concerned if I die, all my money's going to go to my second spouse, and he's going to die, so I'll go to his kids. So we can use a trust in that situation where we put all the money into a trust, and it says right off the bat that half's going to go to his kids, and half's going to go to her, some sort of. Then we also use trust sometimes for tax purposes. When you die, just like income tax, there's a state tax and a federal tax. The federal tax doesn't kick in until you have more than $13 million for the husband and $13 million for the wife, so that doesn't come up very much. But the state of Nebraska tax almost always kicks in. Each person, each beneficiary, well, the wife, husband gets everything free without tax, but after the second you to die, then each person gets the first $100,000 free. Then it's 1% tax after that. There's not much planning. There's not much planning you can do to get around the tax. It's pretty minimal. So usually we don't do tax planning for the state of Nebraska inheritance tax. So that's a whirlwind. But if there's any questions, I'll hit those up for you.
That's great information, Dan. Yeah, does anybody have any questions? Feel free to jump off mute. You can absolutely put them in the chat as well. I had a really quick question when you were talking about like the paper forms and having them in a fire safe. How do you feel about just keeping things electronically in today's day and age?
I guess everybody's got their own personal preference. I I don't mind electronically if it's also just personal preference, also hard copy,
Okay.
um, because sometimes we can't get into
Mhm.
electronic accounts. There's a special procedure to deal with Facebook and Twitter and all that.
Mhm.
But sometimes if computer's locked down and we can't figure out the password, it might be gone forever. If it's on a flash drive or something, again, I guess those can be password protected too. Now, electronic is nice because everything's all together and you can, email it and download it. I guess just personal preference. I like both.
Yeah, makes sense. Okay. Oh, we do have a question. If you have a family member out of the country, will you be able to put them as your power of attorney or on your will?
Um, yes and yes. And so again, I've been practicing 30 years. When I started, we would always make the power of attorney people in town. But now with um, Zoom, like we're doing now, communication is really easy. And so you can be in Boston and communicate with the doctors. And same with the will, you can give assets to people in other countries. It is problematic to name a guardian who lives in a different country, or if you wanted your kids to move to another country after you're gone, it would just it's possible, but there's just a court procedure that we have to jump through to make sure that it's all legal and doesn't look like the kids are being absconded.
Sure. Great question.
I had a
Anyone
quick
else?
question. My husband and I met with an attorney and we expected that we were going to set up a trust. And she actually suggested that we not set up the trust. We are a blended family. And she mentioned maybe when the kids were a little bit older, which I mean, now they are. But do you ever suggest that on the trust, like waiting? Because she said sometimes that's hard, it's hard to access the money, like to take care of the kids. Does that make sense? I'm hoping I'm remembering what she had told us right, but I was just so surprised about the not setting up the trust.
Well, yeah, two answers. First, we typically create a trust in the will for kids because kids in Nebraska can't own money until they're 19 years old. And so in the will, we say if husband and wife both die, everything goes to the kids, but it goes to a trustee that holds the money for the benefit of the kids. Trustees to use the money for their benefit until a certain age, and then at a certain age, they get whatever money's left over.
Mhm.
So I think that's probably what she's talking about. We created a trust, but we're not going to fund it. It's not going to be a real trust unless you both die and they're still kids. But to your other point about why would a lawyer say, let's not do a trust? My mantra is usually simpler is better. I've got people that want to trust just because it sounds fancy. And again, I'll do it. And sometimes we kind of make these spider web type of situations where this trust owns that trust, and you get like six different trusts with different entities and things, and it just gets complicated. And if we're funding all those trusts need tax returns each year. Most things can be handled with a simple will. And even if you don't have a will, um, most of the time, um, the state of Nebraska provides what happens if you don't have a will and you pass away. And most of the time, it's about the same as what you would write in your own will. It says, Nebraska says the spouse gets the first half. It says the spouse gets the first half plus $100,000. Um, and then, and if you have no spouse, then everything goes down to your kids. If you have no kids, then everything goes up to your parents. And if you have no kids and no parents, then it goes sideways to your siblings. And if you have no siblings, then it goes out to your aunts and uncles, which is typically what I see people write in their wills.
Okay, thank you.
Great questions. Anyone else?
Yes, so I currently I currently have brokerage accounts for my children. Um Now granted I'm in a different state, but I don't really think that matters too much. So you're saying that even though I have brokerage accounts, a simple will would be fine as far as like I don't want them to have access to it until like the age of 25.
Correct. And which brings up a good point. The will only controls things that you own directly in your own name. So first off, if you own something jointly with your spouse, if you pass away, he still owns it, and so you can't give it away because he owns it. Or you own something jointly with your brother. If you pass away, your brother still owns that thing, so you can't give it away. Will. The other thing that you can't control are contracts, things that have beneficiaries. So the brokerage account, um, I don't know how it's structured, but it might be that it's in your name, but the beneficiary are your kids. And so even if you say everything goes to Joe in my will, this is a contract. And if it says this fund goes to my kids, it definitely will go to your kids because that's it's a contract, and that's what happens. Same with life insurance. Even if your will says Joe gets everything, if your life insurance says Jane gets everything from this life insurance, that life insurance will go to Jane. And a lot of checking accounts have beneficiaries, and those are controlling. And sometimes what I see is dad will put his son on his checking account. What he means is, I want my son to be able to come in and write a check for me if I need it. But sometimes when you're filling out the form at the bank, there's small little boxes. You check the wrong box. The box you accidentally mark is um, beneficiary or joint owner or payable on death. And so dad dies, and the bank says, "Yes, son, it's all yours." The son says, "Oh no, I know I'm supposed to split this with my siblings." But then 6 months go by, and the son says to himself, "Well, geez, I was the one helping dad with everything. Maybe you did need to give me this account." So we kind of have that question as to whether dad really intended for him to have the checking account or not. So you got to be careful on those beneficiary designations.
Okay, thank you.